Finally, negligence, the failure of a broker to act in a reasonable and prudent manner by failing to adhere to the standards of care established in the securities industry. As with any other type of negligence claim, as you can imagine, these can take any number of iterations or manifestations. And what constitutes negligence in the securities industry is an evolving question, as it is in many industries. Two recent cases explore what negligence means in 2017. These are cases that happen to be at my firm. The first involves financial elder abuse. The client was victimized by online criminal fraud through Match.com and lost nearly $1 million. Now, state legislatures and FINRA are working to address the increasing prevalence of elder financial abuse. There are both internal and external standards evolving, and the key question here is, what liability will brokerage firms have for their negligence in failing to detect and prevent or mitigate the abuse? It's an open question. I think that it's unsettled. It's clearly an unsettled question, and we're moving toward exploring how that is going to play out as this case proceeds, and I'm sure dozens more will around the country as those standards evolve. The second case involves two companies that fell prey to a fraudulent financing scheme carried out through a well-known international brokerage firm. And here, again, there's clearly a third party that is at least partly responsible for the fraud and for the loss. And the question becomes whether the firm, by ignoring red flags signaling criminal misconduct, including multiple prior lawsuits, including the fraudster being kicked out of a prior brokerage firm, the question is, does that meet the test for negligence and liability? And we're going to find out.